So far in all of the lectures, I have been emphasizing the fact that a copyright is created the very moment that the work is created. So a related point that I'd like to clarify is that when I say that copyright exists the very moment the work is created, I also mean to point out that the work has to be recorded in a permanent, that is, in a tangible form. So even though copyright relates to an intangible property right because it's an intellectual property right, but always remember that in order to claim copyright, you have to be able to point to something physical, something that actually exists. So the key point is that all works of authorship have to be fixed in a tangible medium of expression. And let me explain by way of an example what exactly I mean to say that copyright exists upon fixation of your work in any tangible medium. So let's say that you write a story. Now you're the author of that story, but that story obviously has to be written down, and that story is going to exist in the form of a book. So you see that book itself is a tangible medium. And let's say that you record a song, so the recording of the song is going to be existing in a tangible format. Or if, for example, you have painted a very beautiful painting, then once again the physical form of the painting is going to be the tangible medium of expression of your art. So the copyright exists in that painting or in that book that you have written. So always remember that you need to be able to distinguish the copyright in an item as opposed to the property right that exists in that item as a physical thing. So let me repeat this once and then I'm going to explain it. It's very simple, so don't freak out. Copyright in an item is distinguished from property rights in that same item as a physical thing. So let's say that an artist paints a painting and you buy that painting. Now, since you paid for that painting, you are the owner of that painting. Why? Because the property right belongs to you, you paid for it. However, even after you have paid for it and you acquire the property right in that painting, but the copyright of the artist in that painting is going to continue to exist. So when you see a painting, you need to be able to distinguish between two rights that attach to that. One is obviously the property right that belongs to you, but the other is the copyright in that painting that belongs to the artist even after you have purchased the painting from him or her. And the same goes for a book. So the story that is written inside a book, that is the copyright in the content of the book belongs to the author of the book, and the book itself, once it has been purchased, is a physical thing, that is, it's an item, and the property right in that item, that is the book, is going to belong to the owner of the book, that is the one who has paid for the book. So the first take-home message from this particular lecture is that copyright is an example of an intellectual property right that has to be embodied in some tangible form before you can claim protection. So a permanent record is important. And this means that merely having an idea for a great story or merely having an idea for a great painting is not going to be eligible for copyright protection. And this brings me to the second important take-home message, which is related to the first one obviously because they're both interrelated. So the point is that a copyright protects the expression of an idea, not the idea itself. And this second point may seem very simple at first, but it's extremely important to understand that since copyright protects only the expression of an idea and not the idea that is being expressed, so what this means is that information that is included in a copyrighted work is not protected against use by others, although what is protected is the copying of the presentation and the arrangement and the way and the form in which those ideas have been expressed. So let me give two very simple examples to explain what I just said. So let's take news articles for instance. If we say that the information in a news article or the underlying facts within that article then that simply means that no other newspaper can publish any news related to that same piece of information, although it is very common to see the same piece of news being circulated in different newspapers. So this is exactly what I was trying to explain, that when you say that a work is protected by copyright, then you need to be clear about what is protected and what is not protected. So what is not protected is the underlying facts, ideas, principles. So basically all of the information that is contained in the work is not protected. And instead, what is protected is the unique expression of those facts, the unique expression of that information, the way the ideas or principles have been shared by one specific author. So obviously, as we all know, that even the same piece of news can be written in many different ways, because everyone has their own unique way of expressing the same facts. And in fact, variety here is the spice of life, and we find articles that are written on the same topic by different authors, and they are all based on the same underlying information. So that was one example, and let's take a look at another example now. Let's take my own YouTube video for instance. In this lecture, I'm explaining the topic of copyright, and obviously most of the information that I'm explaining here has already been explained by various different authors in either some blog article or maybe some journal article or maybe in another YouTube video. But does that mean that I am not free to create yet another video that explains copyright laws? So you see, the content of my video is based on information that is already available to the public through other mediums. That is, it could be another lecture, it could be another video, it could be another article. But the difference is that my way of explaining the same information, the same content, the same topic is different from another author's way of explaining the same topic. So a simple search in the YouTube search bar will show you that the same information can be explained in different ways by many different creators. While some videos may be downright boring, where the creator is simply reading out from slides, for example, copyright law is blah 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 blah. And there may be other videos where the creator has put in a lot of time and effort, and of course has the relevant editing skills required to make animated lectures to explain the very same topic. So I hope that these two examples have made it clear to you that copyright is not going to protect the information that is contained within the work, and instead what is protected is the way that you have expressed that information. So it's the unique presentation of the same information, the unique expression of that same information that is going to be protected. In short, we have discussed in this lecture how a copyright protects the expression of an idea and not the idea itself. Now, a related question is, what about the creation of works about the same theme by different authors? For now, I leave you to think about it, and I'll answer this question in the next lecture.